168.31A. I do find Judge Murray's analysis regarding the availability of an Article 2, Section 4, Sub 1, Sub H audit beyond the Secretary of State's audit pursuant to 168.31A to be persuasive. There is no right, either in the constitutional section or the statute, for the independent audit that Mr. Bailey seeks. A petitioner under Article 2, Section 4 does not get to choose his own audit criteria. Rather, the legislature has given that authority pursuant to Article 2, Section 4, 1H of review to the Secretary of State. So while a citizen may seek to audit the results of a statewide election, it must do so according to the law. That law provides for performance of the audit by the Secretary of State. There is no other relief available to the plaintiff on this point. As the plaintiffs have either received all of the requested relief from this court or are not entitled to the relief requested as a matter of law, pursuant to my previous discussion, the plaintiff's claims are in fact moot. Granting judgment to plaintiff on its claims would have no practical legal effect, as the audit available under Article 2, Section 4, 1H has already been done. There is no reason to do it twice. As the plaintiff has no additional relief available, there is no need to review the remaining counts that it has brought. The plaintiff's claims in this case are moot. No additional relief is available, and therefore no claim has been stated. Summary disposition is granted to the plaintiffs as to plaintiff's complaint under 2.116 sub C sub 4. As an aside, the court would note that at its core, this case has involved from the beginning something that we all learned to do in kindergarten, and that is count. We've, over time, and perhaps with good reason, in the conduct of our elections, taking this very simple function and made it into a complex and often computerized exercise. By deciding this motion, the court is not saying that there were no problems in the way that Antrim County conducted its November 2020 elections. The clerk has admitted that there were challenges and problems in the elections, although the hand count ultimately of the presidential election showed results largely consistent with the canvass totals that were entered by the state and reported by the county. Nor am I saying that the processing of election data here wasn't corrupted or corruptible. I don't have the facts to make that determination. The plaintiff's reports and the news of the day, including a computer hack recently of a main petrol fuel pipeline on the East Coast, might well suggest that this is something that policymakers should be looking into in the future. If election results were to be held for ransom in the future, one can only imagine what would happen. I am saying that, as pled, the plaintiff's request for an audit is not available. Anticipating the possibility of appeal, this court will take all pending motions under advisement. This court's order with regard to the preservation of ballots, etc., entered in December is stayed. I will need an order from Mr. Grill as to my decision today for the reasons that have been stated on the record. All right, thank you all very much, and good luck going forward on this case.
Thank you, Your Honor.
Just, Your Honor, before proceeding, just to be clear, all other matters are taken under advisement. There are some discovery matters open this week. Should those also be stayed as well?
Yes, it's my anticipation that all matters will be stayed pending. We'll see what the parties wish to do with regard to appeal, but pending the possibility of appeal.
Okay.
All right. Thank you all.